Attorney, please don't interrupt. Attorney General, will you lead the arguments or will you respond to the arguments?
Yes, I will respond, my lord. Mr.
Sir, this is very unfair. My lord, the Chief Justice, this is very unfair. आपने कहा था कि अटॉर्नी जनरल साहब को आर्ग्यू करने दें, हम आपको बाद में सुनेंगे. अब आप
दिखाइए, ऑर्डर शीट दिखाइए.
जी दिखाइए. This is very unfair. I will not argue if you don't want to hear me, but don't put things which are factually incorrect.
वैसे अगर कोई बात कर रहे तमीज से कोई हर्ज होता है वैसे?
नहीं सर, आप अपने असलूब को देखिए, आप अपने असलूब को देखिए, फिर आप हमारे मुतालिक बात कीजिए.
देख लेते हैं.
आपका अपना असलूब ठीक नहीं है. ख्वाजा तारिक रहीम साहब ने इसी वास्ते आ जाने से इनकार कर दिया क्योंकि योर लॉर्डशिप वाज वेरी अनकाइंड टू हिम.
प्लीज डोंट argue on behalf of those who are not present.
Sir, he is my colleague. He has instructed me to inform you this.
सुन लीजिए, ये सब जजेस ने साइन किया है.
Mr. Imtiaz Rashid Siddique, representing the petitioner in Constitution Petition number 6 of 2023, who was partly heard on the last date of hearing, states that he does not want to add anything further and that his written submissions may be read.
कौन सा order है?
Thank you very much. Now please take your seat.
Mr. Zahid Ibrahim.
I must lodge my protest.
Please take your seat before I issue something. Please take your seat.
Mr. Zahid Ibrahim, followed by Mr. Salahuddin.
It's as you wish. If you want to go last,
I'll go last.
As you wish. Everybody who comes, please introduce themselves. Who are they for?
I'm representing PMLQ.
Have you filed anything?
Yes, my lord. I filed CMA 3991 of 23. I'll be very brief, my lord.
3991
of 23. My lord, I'll be very brief and to the point.
Take a second, just let us get it out. CMA.
What is CMA number, right, sir?
My lord, 3991. May it please your lordship. We've heard various...
Do we need to have it before us or we don't need to have it before us?
My lord, if I do, I'll sort of, to a very limited extent, I'll refer to that later. If I may just address, my lord, that we are trying to understand the various meanings hidden within the few articles of the Constitution. In order to do so, the basic rules of interpretation which, according to this honorable court, have been, are to be utilized in reading and understanding these provisions. First, let us just identify that. How are we to read these articles? My lord, the Honorable Supreme Court in the Sui Southern Gas case, 2018 SCMR 802.
802.
802, my lord. The court summarized.
Have you given a paper poke or something with these?
My lord, ये तो judgments.
Judgments.
Judgments की मैंने I'd given the list. I'd given the list in the morning.
Okay.
Yeah, you mentioned it in paragraph 3 of your CMA. In the case of Sui Southern Gas.
My lord, because
you have reproduced.
I want to read the just one sentence from the judgment.
Relevant page?
My lord, relevant page is at 830.
830.
830. What the court did here was it looked at all the case law, it looked at all the treaties from A.K. Broi Saab's to Justice Fazl Karim's to Servai Saab's, and it summarized the rules on how we are to interpret Constitution. And my lord, those rules are summarized on page 830. A through I.
830.
I will not read all of those, but on the next page, 831, the Supreme Court cites with approval a judgment, and that is at paragraph 14b. उसका एक I mean, that sentence really encapsulates how we are to read these provisions. My lord, paragraph 14b. It's a Indian Supreme Court case which has been cited, and it says, the cardinal rule of interpretation, however, is that words should be read in their ordinary, natural and grammatical meaning subject to a rider. First rule is cardinal, ordinary, natural, grammatical meaning, subject to this rider. My lord, I'm reading from 14b, paragraph 14b. Subject to a rider. That in construing words in a constitutional enactment, conferring legislative power, the most liberal construction should be put upon the words so that the same may have their effect in the widest amplitude. This is the basis on which we are to interpret these provisions of the Constitution. My lord, with regard to entries,
Mr. Ibrahim, this principle is applicable in all eventualities?
my lord, that is what this judgment says. And I'm just setting out the basic rule that the Supreme Court has set out. And then, my lord, at page 838,
There is absolutely no departure from this?
no, obviously, my lord, we make departures when we are reading and in trying to interpret. But a basic rule is set out. First of all, you determine what are the rules of the game on how do we read these provisions. And one of the rules that it says...
You see the situation which has arisen out of the proceedings which are going on, whether this en bloc interpretation is applicable?
In my view, yes.
This, how come?
In my view, yes. And I'll come to that. My lord, on page 838, entries of the legislative lists on how they are to be read are also, the rules on that have been summarized. And if we see 838, the rule set out in paragraph 2, in construing the words in an entry conferring legislative power on a legislative authority, the most liberal construction should be put upon the words. 3, while interpreting an entry in the legislative list, it should be given widest possible meaning and should not be read in a narrow or restricted sense. 4, each general word in an entry should be considered to extend to all ancillary or subsidiary matters which can fairly and reasonably said to be comprehended in it. My lord, if we read these provisions, now coming to the matter at hand, my reading in relation to the practice and procedure part of this law, I'm not referring to the appeal part, the practice and procedure part. My lord, the legislative competence, in my view, arises from Article 142A, where the Parliament can make exclusive power to make laws in respect of matters in the legislative list, federal legislative list. From Article 142, I look at the federal legislative list and I look at entry 58. Entry 58, matters which under the Constitution are within the legislative competence of the Parliament or relate to the Federation. Matters which under the Constitution are within the legislative competence of Parliament.
You see, if you
What are the matters?
go by that argument, then there is no need for any other entry in the legislative list. Just this one article, this one entry would cover everything.
With, if I may answer your lordship's question, that does this provide then complete free hand? No. It is only to the extent, the language is very clear, sir, and it's not all encompassing. It says matters which under the Constitution are within the legislative competence of Parliament. What is within the legislative competence of Parliament? Article 191, and this is where subject to law comes in, and the reading of that provision.
रोजनामा कुदरत की वीडियो देखने के लिए अभी YouTube चैनल पर सब्सक्राइब करें और बेल आइकन पर भी क्लिक करें।